Perhaps the most famous line that if anyone knows anything about Furman versus Georgia, they know this line from the case by Justice Stewart, who said that the death penalty is cruel and unusual the way being struck by lightning is cruel and unusual, meaning random and senseless. The main issues in Furman versus Georgia, very simply, were whether or not the death penalty, as it was then practiced in the United States, violated the Eighth Amendment of the Constitution, which prohibits cruel and unusual punishments. That could, and different justices thought that it meant different things. It might mean that the punishment was itself, per se, cruel and unusual. For example, the lawyer who argued Furman before the court argued that boiling someone in oil would be, per se, cruel and unusual punishment. But then there was a more complex meaning, or a perhaps less intuitive meaning, which was that the way that the death penalty was implemented, the process by which it was implemented, was cruel and unusual.
We find the defendant guilty as charged.
There was tremendous disagreement among the 5 justices in the Furman majority. Bizarrely, in the case, this does not happen very often in the Supreme Court. There are 9 justices on the court. There are 9 opinions in Furman versus Georgia. Every single one of the justices wrote his own opinion. They were all he at the time in that case, including the 5 justices in the majority. And none of the 5 justices in the majority joined any of the other justices in the majority's opinions. 2 of the 5 in the majority thought that the death penalty was per se, in every case, cruel and unusual punishment. Justices Brennan and Marshall. Interestingly, I clerked for Thurgood Marshall years later, and he and Brennan almost always joined each other's opinions. They did not join each other's opinions in Furman. They each wrote their own, saying for different reasons that they thought that the death penalty could never be a constitutional punishment. The other 3 justices did not think that the death penalty was in every case cruel and unusual, but that it was cruel and unusual in the way that it was implemented. So Justice William O. Douglas noted the discriminatory aspect of the death penalty and said that it tended to be imposed on minority defendants and on poor people or politically unpopular people, and for that reason was cruel and unusual. Stewart and White, who were taken to be sort of the crux and the center of what this opinion meant because they were the ones who had changed their minds from the year before, they said it was the way in which the death penalty was widely authorized for many cases, but rarely imposed, so that there didn't seem to be any rhyme or reason to it. To use the words that they used, it was wantonly and freakishly imposed. The immediate aftermath of Furman was dramatic. Everyone who had been sentenced to death, and there were some 600-ish people on death row at the time of the Furman litigation, all had their death penalties invalidated. So they were all sent to the general population. They had to be resentenced to a sentence other than death. Moreover, when the Supreme Court struck down the death penalty as it then existed, anyone whose death sentence was pending, that case had to be dropped. because those statutes were no longer valid. Many scholars of the period think and read through the tone of the opinions that the justices, at least some of them, thought this was it. This was the end. You know, the death penalty, no one had been executed in 5 years. The death penalty was at its nadir in terms of use and popularity in the United States as sort of the tail end of the 1960s. But given that the crux was all about there wasn't enough guidance of juries, well, that looked like something that could be fixed. States went back to the drawing board to try to create new death penalty statutes that would guide juries in their sentencing discretion. And within 4 years, 35 states and the federal government had all reauthorized the death penalty. So it was pretty clear that the Supreme Court was going to have to weigh in again and say whether these new and improved death penalty statutes could survive constitutional scrutiny. And that is exactly what happened. 4 years after Furman, in 1976, the court granted cert on 5 of these new statutes. There are 2 ways of looking at Furman that are both completely wrong. One is, Furman, tremendous victory! Incredible lawyers who, against impossible odds, got the death penalty declared unconstitutional by the Supreme Court. Obviously not a great way to look at Furman because it lasted exactly 4 years and then was reversed. Other way to look at Furman, complete failure. They thought they won, but they lost 4 years later, the end, too bad. Also wrong. Furman set in motion a dynamic that continues today where the Supreme Court has placed itself as the arbiter of the legality, the scope, the shape, the rules of the American death penalty. That, paradoxically, that regulation has led a lot of states to abolish the death penalty. At the time of Furman, 40 states had the death penalty. Today, 27 states have the death penalty. So it's not ancient history. It's neither a tremendous success or a terrible failure. It's sort of a complicated story of unintended consequences, and the echoes of Furman continue to this day to have tremendous impact.